Hello, everyone. Welcome. Thank you for joining. My name is Monica Yellowtail. I will be helping host this webinar. Before we begin, for those who may not know, Redwind is a nonprofit organization that provides tribal technical assistance on a variety of programs, including but not limited to HSS, CY, and elder abuse. This ranges from policy review to email to via site visits. If you're interested, you can contact me at monica@redwind.net. You can also visit our website at redwind.net for additional information on services we provide, upcoming events, resources such as handouts and guidebooks that you can download. This presentation was brought to you in partnership with Redwind Consulting. This project is supported by grant number 15 JOVW 21 GK02197 STOP, awarded by the Office on Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this publication, program, and exhibition are those of authors and do not necessarily reflect the views of the U.S. Department of Justice. As it states, this training is part of our Tribal Governments Project. Presenting with us, we have Patty and Leslie. I'm going to pass it over to our presenters.
Thank you, Monica. Well, my name is Leslie Hagan. I serve as the National Indian Country Training Coordinator for the U.S. Department of Justice. I've been in my current position almost 14 years. Prior to that, I spent 5 years at the Department of Justice in Washington, D.C., working as the Native American Issues Coordinator. And previous to that, I was an Assistant United States Attorney in the Western District of Michigan. Patty?
Thank you, Leslie, and thank you also, Monica. It's really an honor to be here with you today. I'm Patty Powers. I'm a Senior Attorney Advisor with Equitas. I have served with my colleagues at Equitas for just about 9 years now. And prior to that period of time, I was a Senior Deputy Prosecutor in Washington State. I had the opportunity to supervise our sexual assault and domestic violence unit and spent a great deal of time in trial on those cases. And I want to mention that because I really had the privilege of working with other multidisciplinary professionals, which is part of what Leslie and I are going to address today. So I'm excited to have a chance to share that experience with all of you.
So our objectives for today, we are going to identify unique challenges faced by American Indians and Alaska Natives living in urban areas who are victimized by domestic violence, stalking, sexual assault, and sex trafficking. We aim to provide culturally responsive support to American Indian and Alaska Native victims living in urban areas, and we want to enhance interjurisdictional coordination to enhance support to victims and reduce gaps in services. So what we plan on covering today is a host of things, and we only have 90 minutes, so we will be pushing through urban Indian issues, building a multi-jurisdictional response. I'm going to go through some case examples where we're going to talk through who has jurisdiction in a particular case, reference some of the programs for urban Indian victims of intimate partner violence, talk about the role of the government, Savanna's Act, and Executive Order 14053. So this I actually pulled off the Redwind website. And this is, I think, a great slide, gives some good information about urban areas with the highest population of American Indians and Alaska Natives who are affiliated with at least one federally recognized tribe. So you can see the 4 leading areas in the country are Arizona, Oklahoma, California, and Oklahoma City. So Tulsa being number 2. So I just think that's some great information. And, you know, for those of us that work with federally recognized tribes, we have to always be very mindful that the majority of Native Americans do not live on the reservation. And in fact, many of them do live in urban areas. So this is a little bit about why culturally informed urban services are critical. So we want survivors to have access to culturally informed advocacy. We want survivors' tribal identities to provide relevant healing in traditional forms. That's something I was always very mindful of when I was working Indian country cases off the reservation. And we want resources that are knowledgeable in state, tribal, and federal law as it pertains to survivors' unique legal status, and resources that are knowledgeable in custom and practices. So again, this is information that I pulled off of Redwind's very good site. And just again, some more information for those of you that are looking at this webinar and you're interested in more urban programs and what's out there for urban survivors of intimate partner violence. This
Yes,
again,
that slide.
okay.
Yeah.
Okay, great. Thank you. So, you know, multidisciplinary, Patty mentioned that, and how important that is for those of us that work in Indian country or with tribal communities. So as I said, I was a federal prosecutor. So any success that I had in litigating cases and working with victims in Indian country was because we practiced as a multidisciplinary team. So the federal government is almost never going to be the first responder to a crime scene, particularly domestic violence and sexual assault crimes. It is typically going to be tribal law enforcement, or if it's a direct service tribe, Bureau of Indian Affairs. So it's very important that we do work together as a team, not only a team within one jurisdiction, like the federal government, you know, working collaboratively as investigators, prosecutors, and advocates, but then also layering on that our counterparts that work for the tribe and also in some circumstances for the state.
So we're going to focus now on some crimes that occur in urban areas, certainly, as well as in reservations. We're going to talk about sexual assault and domestic violence.
Sorry, Patty, I am trying to advance it.
It is totally okay. No worries at all. And talking now about intimate partner violence. And if you take a look at this graphic, we can all relate to this because many times on the surface, we can see a victim being harassed. We can see physical evidence of harassment. And after we're notified by a victim about their fears of stalking behavior, we can also take a look at this conduct and very often corroborate it through investigations. Emotional abuse sometimes may be ascertainable on the surface, but very often it's hidden, it's beneath the surface. And many victims are not in a position to be able to immediately report or disclose their emotional abuse. Physical violence as well, so very frequently as part of intimate partner violence. And while very frequently as service providers and allied professionals, we become aware of really some of the symptoms and certainly the signs of physical violence, many times it goes even more deeply. Sexual assault is a vastly underreported crime in terms of intimate partner violence. And the reason that we're covering this, it's so important for us to know that victimization really is multidimensional. It may very well not just be one crime that a victim is experiencing, but it can be all of these crimes that we're focusing on now and even additional crimes. And when we talk about co-occurring crimes of violence, we need to be aware that while a victim may present for our care, disclosing one particular crime, there may be other crimes within the family unit that a victim is not able to or has been threatened about disclosing. There certainly can be adult physical assault as well as sexual assault. And as I mentioned just a moment ago, sexual assault is very underreported in intimate partner violence cases, but we still need to be able to ask appropriate questions and be victim-centered in that inquiry to determine whether sexual abuse is also present. Similarly, a child in a home may also be the victim of physical assault as well as sexual abuse. And we're all aware also that children witnessing these crimes are also victims of that crime, although maybe in a secondary sense, but certainly a very direct sense. elder physical and sexual assault. If an elder is in the home, they also may become or be a victim of the perpetrator in terms of either physical or sexual abuse. All of the members of a family unit may further be the victims of stalking behavior. We know stalking to be a form of control, a form of an offender conveying to victims, I am always there. You can't do anything without my knowledge. And stalking can give them that kind of control. In the era that we live, cyber crimes are also very frequent. And so we look at all of these crimes and really need to be open to their presence within the family unit. Tragically, homicide can also occur and does occur. We know that there's linkage very frequently between sexual violence and homicide. So that just underscores how important the work is that you're all doing when you serve victims in culturally sensitive ways. Stalking and sexual exploitation should also be mentioned. And as I spoke just a moment ago about stalking, it really can be a form of an offender maintaining their presence in the victim's life at all times and really demonstrating a control feature. It's a course of conduct that's directed at a specific person that would cause a reasonable person to feel fear for their safety or the safety of others, or because of the stalking, suffers substantial emotional distress. And we know also that sexual exploitation can certainly be a feature of sex trafficking. Intimate partner sexual assault can also fall under this umbrella of sexual exploitation, and the perpetrator of the crime may even be a trafficker in certain situations. And currently, we know that in our world today, that image-based sexual abuse is tragically not infrequent. There may be by the perpetrator an unlawful distribution of what might have been initially consensual, intimate images, or may have been taken of an unsuspected victim who may have been drugged, as an example, or otherwise be unaware of that particular crime. Sextortion and doxing are also part of sexual exploitation. The reason that Leslie and I are talking about these co-occurring crimes, we want to ensure that everyone having the privilege to respond to victims in urban areas is sensitized to the very real possibility that there may be more than one crime, and a victim may or may not be able to disclose these additional crimes. And I think all of us who have had the privilege of serving victims really have come to understand the courage that it takes, because victims face barriers, and many of those barriers are created by the offender. An offender may threaten a victim directly or indirectly. If you tell anyone, I'm going to kill you, I'm going to hurt you, you're going to lose the children, and a number of other things that may occur. But there also may be systemic barriers. Many victims fear that they won't be heard if they make a report, or that, quote, authorities won't do anything. And it's interesting to note that offenders know this as well. And so offenders, in their messaging and in their attempt to control victims from making that disclosure, may very likely be saying to victims, go ahead and call. Nobody will take your call. They're not going to do anything. And victims have lived with this constant statement by offenders, may become fearful or even think that perhaps their voice is not going to be heard. So clearly, an offender may create this kind of a barrier, and victims who may not repose strong trust in criminal justice system, they may be concerned about the system's response to their victimization as well. So it's critical for prosecutors and all who serve as multidisciplinary professionals to recognize these barriers, because, we do have a role in trying to break down these barriers and to try to support victims in their ability to make a disclosure and support them as they try to participate in our efforts to serve them. The bottom line, though, is that a victim may be unable to proceed if they perceive that they're not going to be safe. And a victim's safety, as we all know, is always going to come first. I want to mention just a moment some exciting work that's been done through the Sexual Assault Kit Initiative. And many of you on this webinar today may be familiar with the work, but I want to just briefly mention that untested sexual assault kits around our country that were not tested for an extensive period of time have been tested during the past several years and are still being tested. And we've learned a lot from the invaluable research that's been done. And it's told us more and more about offenders of sexual assault. We know that there are essentially three typologies of offenders: suspects that are known to the victim. They may be in a relationship or there may be an acquaintance, but a victim knows them. We know that in this particular group, that there is a significant percentage of serial or repeat offenders who have committed this crime more than once. What's also interesting to all of us who serve in our capacity as providers is that there can be crossover offending. An offender may commit a sexual assault against someone they know in a relationship and may have previously committed this crime against someone they do not know, or may go on to commit this crime against someone they do not know in the future. And there also is a possibility, as we mentioned earlier, about the commission of other violent crimes. So that's how serious the offender is that we're focusing on as we come together to serve victims. Similarly, suspects who are unknown, they used to be called strangers, but now we call them unknown, because even when a victim knows an offender, at the moment of that rape, that person is the stranger. That's why we started developing the different typologies. And we know that these individuals may be serial or repeat offenders. They may cross over and they may commit other crimes as well. I want to just briefly touch upon this third area, the hybrid offender. This is a suspect that the victim knows. And you notice those quotation marks? The victim knows or thinks they know the offender, but this person really is unknown. A great example of this would be dating app perpetrators. Victims will meet someone on a dating app, engage in some social chat for a period of time, and at a later time, they may meet up with the perpetrator. And we're seeing in these particular groups also the potential of serial offense, crossover offense, and other violent crimes. So to summarize this, when we talk about who the offender is, it's so important for all of us as service professionals to recognize the danger that the victim is in, and to also be cognizant of the danger that this person presents within a family unit, within a tribal community, and the community at large. So what we want to do then is to come together, as Leslie was mentioning, as a multidisciplinary team, always in a culturally sensitive manner. And we want to be able to provide for the victim's safety. And we know that safety can be physical, but I want us to know also that safety might be psychological as well. If an offender, for example, is in custody in a correctional facility, it's so important for us to have good relationships with those authorities, so that if a person is going to be released or is going to make bail, we need to be able to provide that information right away to the victim. We want to certainly obtain protection orders whenever that is possible. But there's more to a protection order, as we know, than just the paper. It means supporting the victim and giving them access to make a report to authorities if there is a violation of that protection order. And we need to ensure that there really is a rapid response to the victim's call for help. In this way, we really are trying to meet the victim's needs, and offender accountability is one of those. We want to make sure that we are supporting victim autonomy by allowing a victim to have all of the information that is necessary to them, or for some victims, less is more. But whatever that need is for the victim for more or less information, we want to try to ensure we're doing what fits best for them. It's important also, if the case is in a criminal justice system, that we make sure that a victim is included in decision-making. We never want a victim to be unaware that a charge is being brought, or to not be consulted if a charge is going to be resolved in some way other than the original charge. Victims have this right to knowledge. Privacy is critical for victims. It's like oxygen. So many victims fear if they step forward and disclose a crime that's being committed against them, that the world is going to know, that everyone is going to know all of the personal and private details of their life, which we need to try to meet those needs for privacy, but to be very honest about it. Some information is going to be necessary to be provided to others so that there can be due process if charges are brought in the case. Information, though, may be redacted, and what that means is personal identifying information, perhaps an address, or access to a cell number or a social security number or other identifying information. It may be possible, depending upon the jurisdiction, to redact that from the report. But the original is always kept intact for the court's review. And finally, in terms of privacy, if the case is in court, we want to ensure that only information about the victim is going to be part of the litigation that is relevant and material to the charges. If, for example, there's been prior counseling that is not something that is germane to the charges, we're going to litigate that and ask the court to prevent that information from being disclosed. And then finally, timeliness. I know we're all diligent because the work that we do it's really a privilege to serve victims. They're the heartbeat of our work. But we need to try to be as diligent as we possibly can, even given large caseloads and many other commitments. If there are motions, for example, in a court proceeding to delay this, we need to ensure that they really are for good cause, because we know as service providers, as professionals, that victims are almost being asked to keep their lives on hold, and we want to minimize that delay as much as we can. So when we talk about protecting victims, you see a number of features of the kind of protection that we can offer that are reflected here. Advocacy is invaluable. Both systems-based and community-based advocates are of amazing support to victims. And without advocacy services, so many victims would not have that necessary support and that encouragement and have their questions answered about other services. Advocates also have remarkable insight into danger assessments. And I know prosecutors very frequently are working with advocates, trying to put together the best possible assessment of danger that the victim is in. And safety planning as well is something that requires a multidisciplinary response, including the prosecutor and law enforcement and advocates. Going back to what we talked about before, the danger presented by this offender, so important that we keep a laser-like focus on the offender and the danger that they present to the victim and possibly other victims. We also will obtain protective orders and really have a rapid response to a violation of any of those no contact conditions.
So I mentioned a little bit earlier about how, the federal government as a jurisdiction, we operate multi-jurisdictionally, and, the tribe may have that same multi-jurisdictional response to crimes, which could involve law enforcement, prosecutors, advocates, mental health professionals, sexual assault nurse examiners, community stakeholders. The list is really can be very long. So we need to remember that multidisciplinary, who's a part of that team is going to be driven by that community. And this works for the tribes in both the lower 48 and in Alaska. So this is a graphic of some of the different entities or agencies we may see involved in a case. And the graphic here is if we have a child victim, you know, and that child's non-offending family can be a part of that. And you can see all of the different components that may be responding to that particular case. And let's say this happens on a reservation and that these are in this wheel, all the different spokes that you see, the different agencies are all responding to, you know, wrap around that child, support that child, help that child heal, and also, you know, provide like benefits for the community. So we may have where this particular wheel is placed stacked one on top of another if we have federal and state. So being able to organize that, stay in good communication is something that can definitely take some time, but is well worth it. And it is required in order for us to do a good job for the victims that we serve. Patty?
And at the heart of our work are these critical considerations. We know, as I previously mentioned, that victims may experience more than one crime and may not be able to disclose or may not recognize the other crimes. So we need to really focus on identifying specific and complex trauma that victims may have experienced, particularly victims of sexual violence. They may have been victimized earlier as adolescents, if they're now adults, and perhaps even as children. They may have suffered post-traumatic stress disorder, and the current crime may have served to reignite the sequelae or the fallout of previous PTSD. So it really is a complex trauma that we may be prevented with. And it's so important for us to be open to the possibility of prior victimization. We're going to want to develop strategies for offender accountability. That's very important because we know that this person presents a danger to the victim as well as to the victim's family and to the community itself. But at all times, we want to make sure that we are prioritizing the victim's physical, and as I mentioned earlier, their psychological safety, their privacy to the extent that we can, and we need to honor their autonomy. We do our work because of the victim. When a victim presents to us for our care, I like to think that they're reposing their trust in us. And stand back and reflect on that for just a moment. It really is a significant honor that we're responding to, as well as a responsibility that we have. And we need to recognize at all times that the offender is the one who is responsible. It's the offender that inflicted trauma on the victim, and the offender may have made the victim unable to participate in investigations and prosecutions. They may have threatened them with death, harming a family member, taking children away. There are so many different threats that we may not know of that have significantly impacted a victim's ability to step forward. So a trauma-informed approach, as we talked about, is critical for us to discuss. And at the heart of this is ensuring that our approach is trauma-informed, but is culturally sensitive. It's so important for us to remember at all times. We have come to understand that trauma can affect a victim's perception and responses to events. A victim may be terrified by the sight of an offender who has threatened harm. And the way they view the offender, they may view that person as larger than they really are. They may view physical attributes as being magnified. And this is because of the experience of trauma. It can also impact their ability to even participate, as Leslie and I have been discussing. Trauma can also cause disturbance within a victim's memory. I know as professionals, we all want to do a good job. We're committed to really doing the best that we can for victims. And we try to be organized in the work that we're doing. But we have to take care when we're talking with victims, not to ask them for a chronological order or a sequence of events. Most victims really want to help us do our job and do it well. And they will try to fill in blanks where they may not have that immediate access to a memory because trauma impacts chronological recall. And so, one way that we've developed that can really help us as service providers to speak with victims is to simply ask a victim, "What are you able to tell us about what happened?" And when you think about those words, that word able takes all of the burden off of their shoulders to try to come up with this chronological order. So then they're able to reflect upon what happened and tell us what they can. And that's so important. And as we ask those questions, we need to really bear in mind the offender is responsible for victimization. And so we need to phrase our questions in such a way so that it's never the victim's fault, but it is the offender's role in how the victim was able to respond. So in terms of responding as providers, as allied professionals, we want to make sure that we are really adapting all of our practices to accommodate the trauma that the victim has suffered. It's about the victim, and we need to really keep that in our perspective at all times and perhaps even modify the way we're doing our work to ensure that it's trauma informed. And the best possible thing we can all do, and I think Leslie and I are both going to continue to go back to this, is to work together. What this really does, it helps us obtain expertise from other colleagues and really enrich the expertise that we have. And it ensures the broadest possible application of trauma-informed professionals. And we know that with trauma, there are a myriad of different responses to trauma, and it's not one size fits all. There are some commonalities in trauma, but at the same time, we need to know that a specific victim may have individualized responses. So we really have to be open to that possibility as well.
Okay. So I would like to talk a little bit about jurisdiction because, as you know from the title of this webinar, it's on Native Americans living in urban areas who are victims of intimate partner violence. So we need to have a discussion about if something like that happens and there's a Native American in a city that's victimized, who has jurisdiction to prosecute that case? And I teach a lot of police officers Indian country criminal jurisdiction, focusing a lot of the training focuses on non-public law 280 jurisdictions, but we also cover public law 280 jurisdictions. And I always teach my students there's 4 things to really look at to figure out which jurisdiction has the authority to move forward with a case. And the first question is, where did the crime occur? Did it occur in Indian country? In Indian country is specifically defined in the federal law under 18 United States Code, section 1151, but it is late in the day, so I am not going to do a deep dive in the law for fear that I will lose a lot of you, but that's where we find it. So first, the first very important question is, did it occur in Indian country? The second and third questions that we look at is, what is the Indian or non-Indian status of the victim and the defendant? And I use the term Indian when I talk about federal Indian law and criminal jurisdiction, because that is the term that is used in federal statutes and also in case law. So I don't mean to offend anyone. I also use Native American, American Indian, but when I'm talking about jurisdiction and doing a legal presentation, I do use the term Indian because that is a legal term. Excuse me. The fourth thing we look at is, what did the person do? Is that crime something that falls under federal statutes known as the Major Crimes Act, the General Crimes Act, or is it a crime of general federal application? And those are crimes that apply to everybody, everywhere in the United States, regardless of their Indian or non-Indian status. And one of those types of crimes is human trafficking. So the federal code site for human trafficking is 18 United States Code Section 1591. That is a crime of general federal application. So we don't need to go through the analysis of did it occur in Indian country and what is the Indian or non-Indian status of the victim and the defendant. So that is a quick summary of something that typically takes me about 3 hours to cover. But let's see how we do here applying that to these case scenarios. So our first scenario, we have Jane, who is a 30-year-old enrolled member of the Red Lake Nation, so a federally recognized Indian tribe. She is raised traditionally and currently lives in Duluth, Minnesota. She and her boyfriend have lived together for approximately 18 months. Her boyfriend is also Native American. He recently lost his job, has been drinking more, and is becoming increasingly verbally abusive. Last night, he came home late and was drunk. Jane was forced to call in sick because he had the car and she couldn't get to work. When he comes home, she starts to yell at him and said that she will likely be fired because of repeated problems getting to work and getting to work on time. So he screams at her, "Get the F away from me." And when she tries to take the keys from him, he slaps her across the face and pushes her down. She calls 911. So a fairly common scenario, but we have a crime that occurs in an urban area involving two Native Americans. So did the crime occur in Indian country? No, it did not. Now, historically, was it Indian country? Absolutely. But in terms of today's maps, Duluth is not recognized as Indian country under that federal statute that I mentioned. So who has jurisdiction? Well, if it didn't occur in Indian country, the tribe does not have jurisdiction, even though our victim and our defendant are Native Americans. So the jurisdiction that has the authority to prosecute is the jurisdiction where the crime occurred. And it didn't occur in Indian country. So in this particular scenario, the state or the city of Duluth is who has jurisdiction to prosecute that crime. Again, even though it involves two Native Americans, because it didn't occur in Indian country, and there's nothing in this scenario that we discussed that would be a crime of general federal application, it's going to be the state or the city that has jurisdiction in this particular scenario. Okay, let's look at a second one. Jane is a 30-year-old enrolled member of the Winnebago tribe in Nebraska. She currently lives in Omaha. She and her boyfriend have lived together for approximately 18 months. Her boyfriend is non-Indian in this scenario. He recently lost his job, has been drinking more, and is becoming increasingly verbally abusive. He is also now using meth. So they are behind in rent and face eviction. Joe tells Jane that they will quickly need to raise some cash. He says that he has a friend who will give him $100 and some meth if Jane will sleep with him. Jane refuses. Joe beats her and forces her to have sex with Joe's friend. Joe now regularly forces Jane to sleep with strangers. Jane develops a sexually transmitted infection, seeks treatment, and then she tells the nurse what has been happening, and the nurse calls 911. So again, looking at our first question, is this a crime that occurred in Indian country? No, it has occurred in the city of Omaha. So in this case, we can rule out the tribe as having jurisdiction. But looking at what happened here in this particular offense, I mentioned that trafficking is a crime of general federal application. And I think we have a good argument here that the trafficking statute does apply. So with adults, we have to show that something of value was exchanged for sex and that there was force, fraud, or coercion exerted on the victim. So in this case, the scenario sets out that he has beat her and that he forces her to have sex. And in return for the sex, there's money that is exchanged. So even though there is no, sometimes people think with trafficking that implies there has to be travel between two states. That is not the case. It's the exchange of something of value, and it can be a sandwich or a can of beer. There's no specific threshold to determine the value. Something of value exchanged for sex. And in this case, because we have a 30-year-old victim, an adult, we have to show that there was force, fraud, or coercion exerted upon her. So there is a chance in this case that it could be prosecuted federally. It's also likely that the state of Nebraska also has trafficking laws that may apply. So there may be two different avenues to get this particular case prosecuted. And you're probably beginning to see a little bit about how complicated it can be to figure out who has jurisdiction in a particular case. So let's take one more. Jane is still 30, but she's now an enrolled member of the Eastern Band of Cherokee in North Carolina, and she currently lives in Columbia, South Carolina. She and her boyfriend have lived together for approximately 18 months. Her boyfriend is non-Indian. Again, he recently lost his job, same issues occurring. But in this scenario, Jane kicks him out of the house about 6 weeks ago. And then she goes back home up to Cherokee about a month ago and files for a protection order with the Eastern Band of Cherokee Tribal Court. And the tribal court issues a protection order against Joe and orders that he have no contact with Jane. So last night she was shopping at Walmart in Columbia, and Joe came up and started screaming at her. He also followed her to the car and started threatening her. She calls the police. So, a couple questions for this scenario. Did the Eastern Band of Cherokee Tribal Court have jurisdiction to issue a protection order against Joe because he is a non-Indian? And yes, the Violence Against Women Act has clearly, made it so that tribal courts do have the authority to issue a protection order against any person, and that term, any person, includes non-Indian. So now, is the protection order violation enforceable in the city of Columbia? So can we enforce a tribal court order for the benefit of a Native American living in an urban area? That violation took place in Columbia. Can the Columbia courts enforce it? And the answer is yes. And that is under full faith and credit. So there are a number of criteria that the order would have to fulfill in order to be enforceable. But for purposes of today, we're going to assume that all of those criteria are fulfilled. So yes, that court order can be and should be upheld. And I know it's a continuing issue in some parts of the country, getting state and local courts to enforce tribally issued protection orders. But that statute, full faith and credit, is found at 18 United States Code, USC 2265. So just three quick scenarios there to show you all of the issues that we need to look at when we're trying to ascertain who has jurisdiction to take a case. So what if we have a victim who wants help, but not prosecution? And Patty already mentioned that sometimes victims feel that if there is a case that is brought forward in the criminal justice system, that will put them in more danger. So if we have a victim who lives in Duluth or Detroit or Omaha, are there places that they can go to get assistance? And there may be, and likely are, in all of those areas, urban programs that can provide assistance, domestic violence service provider programs. They may not be tribally specific, but they certainly can provide assistance. And then in many urban areas, there are urban programs that are grounded in culture and traditional practices. I'm from Michigan originally, and I know that there was a urban program, has been one for years in the city of Detroit, that is there to assist Native Americans living in the metro area who want some type of assistance. And then we've got tribal programs. In the previous example, you know, Jane lives in Columbia, South Carolina, but she went home to the reservation and went home to get services. And in this case, that service was getting a protection order issued by the Eastern Band of Cherokee Tribal Court. And then online resources. You know, this is something that has really been a game changer for many, that there is so much help that is available online. That said, if a victim is still living with the perpetrator, or if the perpetrator has access to the victim's phone or laptop, that victim should be aware that there may be an ability for the perpetrator to look at her search history and find out, you know, if she has been seeking help or looking for different remedies. Also, you know, again, just looking online at different programs that are out there, the Indian Health Service, this is a screenshot from their website, looking specifically at urban projects that they have, the American Indian Health Service of Chicago. And you can see on the screen there that you know, specifically works to increase capacity for crisis intervention, looking at domestic and sexual violence, fostering partnerships, providing education and training on domestic and sexual violence to service providers and community members. And then another one referenced on the screen is in California, the Bakersfield American Indian Health Project. So this is just one screenshot on one particular site, but when you start looking, there are a lot of programs available in urban settings for Native Americans that are struggling with issues connected to domestic violence, sexual assault, stalking, etc. And there is the Native Helpline. That's been in place now for more than 10 years. Strong Hearts Native Helpline. And that is, as the slide says, available 24/7 and is a safe, confidential, and an anonymous helpline available for Native Americans and Alaska Natives. So hopefully those of you that work in tribal communities and with tribal communities and with Native Americans living in urban areas, that you can push this link out to them, because it is a tremendous resource. And again, it is anonymous. So the federal government, does the federal government have a role to play in urban issues involving Native Americans? Well, I think from the discussion we've already had on criminal jurisdiction, you know, the answer is it depends and it's complicated. I know that sounds very lawyerly type of a non-response, but it's absolutely true. So in the first example that we gave, where it was domestic violence assault, there is no role for the federal government in that particular case, where we had one Native American assaulting another Native American in Duluth, Minnesota, was the facts. The second example, though, was a human trafficking case. And that was one based on the facts that we had, that the federal government certainly could step in and prosecute that. So as I mentioned, we go through this, you know, analysis to determine who has jurisdiction in a particular case. And I've walked through that with you. And the bottom one highlighted in red, crimes of general federal application. These are offenses that apply to they're federal crimes where the feds have jurisdiction anywhere in the U.S. and regardless of the Indian or non-Indian status of the victim and the defendant. So we've already mentioned trafficking, human trafficking, and in particular, sexual exploitation, the issue that we talked about in the scenario. Other types of federal crimes of general application are gun offenses. So if somebody is a felon and they've been convicted of a felony and now they're in possession of a firearm, Two that may be of very important interest to you all working with intimate partner violence victims. Other parts of the Gun Control Act are 922G8, when somebody has a protection order issued against them. They are not to have a firearm or ammunition for the duration of that protection order. So that is a federal crime, punishable by up to 15 years. 922G9 is when somebody has a misdemeanor crime, a misdemeanor conviction of domestic violence. They are forever barred from purchasing or possessing a firearm or ammunition. And that conviction can also be a tribal court conviction. So again, these are crimes of general application and drug offenses. You know, we know that unfortunately there are a lot of domestic violence cases and sexual assault and trafficking where the sale of drugs is also a part of that relationship. You know, in the trafficking example, the defendant had a meth habit and he was forcing the girlfriend, trafficking her in order to support the meth habit. So maybe a controlled substances violation would apply, and that is a federal offense. So I also want to give, you know, this is the role of the federal government part of this presentation. What can we do in urban areas? I want to go through a couple of statutes and also an executive order, just to let you know that even though we may not have jurisdiction always for crimes occurring in urban areas involving Native Americans, you know, we do a lot of planning and do a lot of outreach, and we can work with urban programs. The first statute I want to call to your attention, the Tribal Law and Order Act, you're probably very familiar with. It's been around now almost 14 years. A couple things about the Tribal Law and Order Act, or TLOA for short. It is intended to establish accountability measures for federal and state agencies responsible for investigating and prosecuting violent crime occurring, and I've highlighted in Indian country. So Indian country, again, is a legal term of art. You can see there on the slide, defined in 18 United States Code, section 1151. So currently in the United States today, there are 574 different federally recognized tribes. 229 of those are in Alaska, but with the exception of the Metlakatla Indian community, none of those meet the definition of Indian country. So every U.S. Attorney's Office, and I believe it's 51, have Indian country responsibility. All of those offices have to have a designated tribal liaison. Typically, that's an assistant U.S. attorney, and that person is tapped to serve as the primary point of contact with tribes in the district. So this is the person who is really a liaison between, you know, perhaps service provider programs, certainly the tribes, maybe even an urban program that is working with Native American victims. So this is, it's good to know who the tribal liaison is for the district where you sit. Those duties were articulated per statute of what the tribal liaison is supposed to do. So coordinating the prosecution of federal crimes occurring in Indian country, developing multidisciplinary teams to combat child abuse, domestic and sexual violence, consulting and coordinating with tribal justice officials and victim advocates, developing working relationships and maintaining communication with tribal leaders, tribal community and victims advocates and tribal justice officials, excuse me, coordinating with tribal prosecutors in cases where a tribal government has concurrent jurisdiction along with the federal government, providing training and technical assistance, conducting training sessions and seminars for officers, tribal officers seeking their special law enforcement commission. So you can see there's a whole host of duties that this particular person in the United States Attorney's Office is tasked with doing as it concerns tribes. So very important person to know and have their contact information. So then we had, about 10 years later, we had Savanna's Act signed into law. And this also added to the Department of Justice and U.S. Attorney responsibilities as it concerns federally recognized tribes. And you can see Savanna's Act there is found at Title 25, and Title 25 is where we find a lot of federal Indian law. And this statute also articulates that one of its intended purposes is to clarify the responsibilities of federal, state, tribal, and local law enforcement agencies. And Savanna's Act is really focused on responding to cases of missing or murdered Indians and also trafficking. So there was a horrific case that was the catalyst for the passage of Savanna's Act. It was in North Dakota. There was a woman, Savanna LaFontaine Graywind, who was lured to an upstairs apartment, and the woman in that apartment killed her and took a utility knife. Ms. Graywind was very pregnant, 8 months pregnant, and the defendant took a utility knife and cut the baby from her womb, and then Ms. Graywind bled to death. Her body was found in a river about 8 days later. Fortunately, the baby survived and is with family and doing well, last I heard, but a really horrific crime. And that woman and her boyfriend were both prosecuted and got very lengthy sentences. But that's the catalyst for Savanna's Act. And again, the focus is on missing or murdered and human trafficking. Another purpose for the law is to increase coordination and communication. So you're seeing sort of a refrain here through all of the things that Patty and I have been talking about, how important coordination and communication are. Congress recognizes that too, and they've put it in many statutes. What I find interesting, because I've been doing this for a while, so I've been coordinating with law enforcement and victim advocates, but Savanna's Act also adds medical examiners and coroners' offices, which, we didn't see in some of the earlier laws that were passed, like the Tribal Law and Order Act. It is also intended to empower tribal governments with resources and information and to increase the collection of data. It can be very hard to get accurate data. So, this data is going to look at missing or murdered Indian men, women, and children, regardless of where they reside. So again, outside of Indian country applies here, can be an urban area. And the sharing of information among federal, state, and tribal officials responsible for responding to these cases. So every U.S. Attorney's Office under Savanna's Act had to develop what is called under the statute regionally appropriate guidelines. And regionally was, it was decided that what that meant is each U.S. Attorney's Office. So I'm from Michigan. There are 2 U.S. Attorney's offices. So there are going to be 2 regionally appropriate guidelines, one for the Western District and one for the Eastern District. So these regionally appropriate guidelines by statute have to include guidelines on interjurisdictional cooperation among law enforcement agencies at the tribal, federal, state, and local levels, including enforcement of protection orders, and it has to detail specific responsibilities of each law enforcement agency. And again, I highlighted in number 2 what I thought may be of interest for this group. It has to include what are best practices in conducting searches for missing persons on and off of Indian land. So in and out of Indian country. Standards on the collection, reporting, and analysis of data and information on missing persons and unidentified human remains, and information on culturally appropriate identification and handling of human remains identified as Indian, including guidance on getting that information timely into databases. Guidance on which law enforcement agency is responsible for inputting information into appropriate databases, guidelines on improving law enforcement agency response rates and follow-up responses to cases of missing or murdered Indians, and guidelines on ensuring access to culturally appropriate victim services for victims and their families. Now, some of you may be thinking, I am very interested in reading this document. Where may I find it? Well, some U.S. attorneys' offices have made the documents public, or a sort of a redacted, maybe abbreviated version, and some have deemed it law enforcement sensitive. And the reason why is, you could see on the previous slide, it said best practices for investigating these cases. So we want to be careful about putting law enforcement sensitive information online or, out in a public facing document, and then sort of tipping our hand to somebody who may be engaged in wrongdoing. Savanna's Act and the development of the guidelines requires that there be consultation. So as the U.S. attorney's offices developed their guidelines, they had to consult with, and you can see the different parties listed on the slide. Again, I've highlighted medical examiners and coroners because that is, someone that we may not have typically consulted with in the past. And then I put in red and bolded urban Indian organizations. So national, regional, or urban Indian organizations with relevant expertise. So again, definitely a role here for urban programs. And then there was a compliance requirement written into the statute. So not later than 1 year after October 10, 2020, the signing of the bill, the U.S. Attorney's offices had to have these regionally appropriate guidelines in place. And then there is an obligation to, modify them and update them as needed. So to the best of my knowledge, I am not the keeper of the regionally appropriate guidelines, but I talk regularly with the person who is, and all of them, to the best of my knowledge, have been submitted to the Executive Office of U.S. Attorneys. So Executive Order 14053. So an executive order is issued by the president. What is notable about the date that this was issued is every year, the White House convenes a tribal leaders summit in Washington, D.C. It's typically done in November to coincide with Native American Heritage Month. And November 15th was the date of the summit in 2021. I believe the president did speak there at it, and also this executive order was issued. So the executive order says a lot. I just wanted to highlight a couple of sections. Again, talks about coordination. So many of these different memorandum, executive order, statutes all reinforce that we need to work together. And you could see here the Attorney General working with the Secretary of the Department of the Interior and heads of other executive departments and agencies shall assess and build on existing efforts to develop a coordinated and comprehensive federal law enforcement strategy to prevent and respond to violence against Native Americans. And this has to specifically include missing or murdered Indigenous people where the federal government has jurisdiction. So again, driving home, it's so important to be able to articulate, which jurisdiction, state, federal, tribal, who has the authority to do what given a particular incident. And then this strategy has to set out a plan to address unsolved cases involving Native Americans, and there has to be coordination among Justice, Interior, and HHS in their efforts to end human trafficking. Also has to include protocols for effective, consistent, and culturally and linguistically appropriate communication with families of victims and their advocates. And again, because there's always accountability built into these things, there was a requirement in the executive order that a report be submitted to the president within 240 days of the date of the order. And that was done. I was on the group that participated in writing it. So I know that has been done. And actually this group still continues to meet. So also promoting coordination of federal, state, and local as appropriate through the development and support of tribal community response plans. You'll probably be hearing a lot more about those from me if you attend trainings that I put on. The Executive Office for U.S. Attorneys has an MMIP program that they are rolling out. And one part of that, one focus of it is assisting tribes if they are interested in creating their tribal community response plans, which is a tribal strategic plan for how to respond to a missing persons case. Okay, Patty, back to you.
I was on mute. Thank you, Leslie. Wanted to spend just a very few minutes talking about some of the exciting developments in new technology that is being applied successfully to cold cases of murder as well as missing persons. So the first step that really takes place is authorities, law enforcement professionals are going to work toward determining what remaining evidence could form the basis of review or maybe analysis. And they're going to be taking a look at a number of different aspects of a cold case file. They're looking for photographs. In much earlier times, there weren't digital photographs. The quality may not be as clear as it is now, but still, there can be information contained in them. Diagrams of a crime scene where a body is located, perhaps with relationship to bloodstain pattern evidence, measurements that are still there, untested evidence from sexual assault kits. Many years ago, it was considered there was only a short window of time when if a victim presented for medical care and submitted to the taking of forensic specimens, there was a thought that only there wouldn't be anything left that could be tested after 3 days. Now we know that there is a greater period of time. And so we can look back to those untested sexual assault kits. And if they've been contained appropriately, we may be able to determine evidence at this point. Other physical evidence that may not have been tested, a pair of glasses that was left behind at a crime scene, there may be residual touch DNA, depending upon how those glasses were cared for in evidence storage. And so there really will be an effort to look back carefully through these case files, and from that point, trying to recreate the crime scene as it was during a much earlier period of time. There's going to be an effort to test not only sexual assault forensic evidence, but also other physical evidence, which may never have been submitted for testing because there was a thought much earlier that nothing could be found. In many sexual assault evidence kits, there is a mixture of DNA. In the past, it was not always possible to determine the male donor profile from a mixture. But now there is a heightened opportunity through scientific advancement to be able to do that. So we're really looking at new technology that is really putting the identification of perpetrators in cold cases so much more within our reach. So I want to just touch upon some of the DNA technology to give you an idea of the hope that we all have for resolving missing persons cases and cold cases of homicide. The first thing that's going to happen if there is a sufficient quantity of DNA, and if it meets the CODIS standards, we're going to upload, law enforcement is going to upload that sample into the CODIS system. And there may possibly be what we refer to as a CODIS hit. And that hit can connect us with a perpetrator, it can connect us with a crime scene, but it can give us a very important linkage that can help us to better investigate the case. One of the interesting inroads through DNA has been DNA phenotyping. For those of you that may have worked on cold cases going many years ago, looking at a cold case file, there might be a police artist sketch of a possible suspect based upon a victim or an eyewitness identification, or there might be something kind of a similar sort of caricature obtained through what was once called an identikit, Well, now with DNA phenotyping, again, depending upon the quantity of the residual DNA and the quality of that DNA, there may be an ability to phenotype and to come up with how a person would have looked during this earlier period of time, the color of their eyes and their skin and hair and other physical features. Bearing in mind, it's not going to be precise because the environment certainly can impact a person's appearance in some respects, but still giving law enforcement more of an opportunity to have something to go on, especially in a case where the identity of the suspect is unknown and there really aren't any leads. A handful of states now have statutes which permit what's called familial DNA searching. This can be an important investigative tool where it's authorized. In other jurisdictions, in the jurisdictions that have this, it's actually condition precedent to a forensic genetic genealogy search. And the primary difference really between familial and forensic genealogy can give law enforcement a much closer connection so that they can build out a family tree and then do the investigation and determine what potential branch of that family tree, as they investigate it, might yield the identity of a certain individual who is a suspect. So the CODIS hit, as I mentioned a moment ago, can inform law enforcement of the match. It might be a match between the DNA that's extant or remaining from the cold case or perhaps a missing persons case, but it tells them about the match. It might match to an offender. Now, remember earlier how we discussed the danger of offenders and the fact that some of them may be serial or repeat offenders. We may learn of other victims through CODIS. It's an investigative lead only, and it can help identify an individual that still needs to be corroborated by obtaining their DNA and comparing it to the original DNA that we've discussed. So it really is an investigatory lead. That confirmatory sample has to be obtained, and many times is obtained through a search warrant or an order for that confirmatory DNA sample. Although sometimes in cold cases, as you probably know, it can be obtained surreptitiously even. A discarded can of pop or a beer can may still have residual DNA and can be compared with that original DNA to corroborate actually the identity of the offender. So I mentioned forensic genetic genealogy. It really is an exciting advancement in science. It really assists with comparative DNA analysis. It measures the amount of DNA that's shared between people in terms of centimorgans. And traditional genealogy really comes into play because once that association is developed, and there are a couple of DNA public databases that allow this with the permission of people who have their DNA in that particular resource, then law enforcement is going to consult with genealogists, and they're going to also use historic records to build out the family trees. There may be some public records of deaths or marriages that can help them hone in more clearly on possibilities. But the descendancy research is usually done by the forensic genealogists, and they'll determine a lead generation based from that DNA and drawing that DNA out and then uncovering a list of possible identities of individuals. So it is a combination of genetic analysis that's done that starts this process, but also employs traditional historical and genealogical research. And it's very interesting. It utilizes what's called SNPs. They're very, very small to determine how closely related two individuals are. It doesn't develop evidence of who that suspect is. That's the work of law enforcement. This is an investigative lead only. It does help narrow down the suspect list. Law enforcement is going to look at the family tree, the lead generation that's already been denoted by forensic genealogists. They're going to look as to how old that person would have been during this earlier period of time. What information do they have connecting that individual or that part of the family to what's believed to be the geographic location of the crime? And significantly, it also helps resolve human remains and missing person cases. It's an exciting inroad in science that really is helping many surviving families have some answers and really bringing about offender accountability where the cases remain cold for many years.
Okay. Well, that was great. And the forensic genealogy stuff is fascinating. I don't think there's a week that goes by anymore that I don't see where there's, 40-year-old case that was solved. So it's very, very interesting. So you have on the screen our contact information. I know for me, please don't hesitate to reach out if there's ever anything that I can do to be of assistance. And I don't know, Monica, if we had some questions, because last time I tried to pull up the chat, I created an issue with the screen sharing. So I'm going to defer to you, Monica, if there's questions.
Yeah, we have a couple questions here.
Great.
Okay.
The first question we have is, what about crimes on a river dividing native land and non-native land? And this is from Bonita Ball.
Okay, well, that probably takes what I covered and makes it exponentially more complicated. So, um, who has jurisdiction in the water sometimes is, there's the high water mark. I mean, there's all kinds of things, but let me just say that if there is a case where we need to figure out if there's jurisdiction and if that case is going to be taken federally, proving jurisdiction and proving that we have jurisdiction, and let's say it's the river that Bonita asks about, if we, through investigation, determine that that part of the river where the crime occurred is actually Indian country, as defined by federal law, 18 USC 1151, that is actually an element of the crime. So we have to prove that to the judge or to the jury beyond a reasonable doubt. So one of the things that investigators do, and when I was litigating cases, we would work very closely with BIA's land management offices. The tribes that I worked with, they had their own land status offices, because we would have to get that information and produce it. So it's not a question that I can answer here, but if there is a question of, is it the tribe's property? Is it the state's property? Is there federal jurisdiction? That is something that federal agents working in partnership with Bureau of Indian Affairs and tribal law enforcement are going to have to work to figure out, and also bring the prosecutor evidence to prove that beyond a reasonable doubt.
Is there any more questions in the chat? I'm not seeing any right now.
Well, I'd like to join with Leslie in thanking you so much for the honor of being with you today. My contact information is up here, my cell number, as well as my email address. I'd be delighted to hear from any of you, and we at Equitas would be privileged to help support your work in any way that we can.
And I would also like to thank Red Wind for this opportunity, and I always like to teach with Patty. So it's been fun, and I always learn from Patty. So again, I thank you all for participating today, and thank you, Red Wind.
Yes, thank you, Red Wing. And Leslie, it's always a pleasure. I look forward to more opportunities.
Thank you to our presenters. Thank you, Leslie. Thank you, Patty. I just want to let the attendees know that there will be a pop-up bubble with a quick survey. If they can fill that out, that is very crucial for us, just to know how they felt about the webinar, if there's anything that we need to improve or change. Thank you, everyone.